Okay, just before we start, I understand there's a question just come in. Will the recording link for the session be circulated? I believe that the recording will be available on the K3 Hub website, and I will ask our team to circulate it to everybody who registered. And with that, I think it's a good time to start. Good morning, everybody, and welcome to the inaugural K3 Hub webinar. My name's Simon Bonney. I'm a Managing Director in Quantum's Restructuring and Insolvency team. And today I will be your Michael Parkinson for this morning's discussion, joined by the Muhammad Ali of tax, Jeremy Johnson. The Q&A function is open on this webinar, so please do submit your own questions in real time. Some of you have submitted questions when you registered, and we'll endeavour to feed those into the discussion. We also have a one-question live poll, which we'd be grateful if you would take the time to complete. This will appear on your screens now, and please feel free to submit questions throughout the webinar. Before we kick off, I am obliged by our very efficient marketing team to ask for your patience if we do experience any technical difficulties at all during the next hour or so. I think that's mainly because they've seen how poor my internet can be. But without further ado, let's begin. Last year, many of you will know that we merged with K3 Capital Group Plc, and since then we've launched the K3 Hub, a member-only club developed by Quantum and K3 Capital Group, the listed advisory team who we merged with last year. Free to join, the club will give members access to a whole host of services, diagnostic tools and calculators, insights and news, and CPD credited events via a bespoke website. The Hub's been designed specifically with professional advisors in mind, providing you with the tools and insight you require to best support your clients and ensure that you're up to date with the latest industry developments. I am delighted today to be joined by Jeremy Johnson, who is a director in inTAX, the specialist tax investigations business. Jeremy manages disclosures, disputes and cases involving HMRC tax and fraud. He also acts as an advisor to clients in litigation on technical tax matters. As a former senior HMRC inspector, he has a wealth of knowledge and insight into the approaches and procedures adopted by HMRC and understands the boundaries within which it operates. So let's get on with it. Turning first to the coronavirus job retention scheme. In September 2020, HMRC suggested that up to 3.5 billion may have been paid out in relation to claims made in error or based on fraud. That was on the assumption that the error and fraud rate in the scheme was around 5 to 10%. 8,000 calls have been made to the HMRC fraud hotline, and they were looking into apparently 27,000 high-risk cases where they believed a serious error had been made. Updated numbers suggest the scheme had paid out around 58 billion between March 20 and March 21. And in response to a Freedom of Information request by April 2021, HMRC said that it had an overwhelming number of reports of fraud. Unsurprisingly, Chancellor Rishi Sunak confirmed in March that he was investing 100 million into the 1,250 strong task force at HMRC to investigate wrongdoing. So, Jeremy, as a brief introduction, can you just take us through the background to the job retention scheme?
Certainly. Good morning, and good morning to everybody who's joining us. I'm sure everybody is well aware, it's been well publicised, the CJRS or the Furlough Scheme, as it's often referred to. But it was a scheme that was introduced last year, 2020, to allow employers to retain their employees, provide a payment that could be made to the employees if those employees couldn't work because of COVID restrictions. It was paying up to 80% of the employees' wages, or up to £2,500 a month. Importantly, it can only be paid if the employee was not actually working, and we'll probably talk about the implications of that. So if an employee couldn't work because of a downturn or because of they couldn't safely be in an office, a payment was made to the employer to cover the wages to be made to that employee. At first, it was all or nothing, full-time furlough or no furlough. And then the scheme was modified a little bit later on to include part-time furloughs for those who were only working 2 or 3 days a week. There could be a furlough payment for those individuals.
So bearing in mind it was a scheme that was obviously understandably implemented very quickly, how rigorous were HMRC in terms of ongoing checks, or how rigorous are they in terms of ongoing checks when the scheme went live?
We know that quite a lot of resource internally was devoted to the furlough scheme. Some senior resource to provide guidance. There was some resource within HMRC that was performing some level of real-time checking of claims. I imagine there was probably a learning process as HMRC itself got to grips with the rules of the scheme. So in the early days, it may not have understood what mistakes were being made as much as maybe a month later, 2 months later, 3 months later. Certainly it was checking them, because one of the first press releases in terms of a criminal investigation was made in July 2020, where HMRC had arrested individuals for furlough fraud. And that was not long after the first payments were being claimed and made. So it's quite clear that from very early on, there was checking, and some of that checking resulted in people being investigated at a very serious level.
And so we talk about mistakes or errors. What really are we talking about in terms of errors that might be seen, that might now be discovered?
Before talking specifically about the types of errors, Simon, I think it's important to distinguish in terms of technically what's gone wrong or how has it gone wrong. To talk about the concepts of errors as HMRC thinks about it, the types of errors that people might be making, whether it's in furlough or otherwise. And there's a spectrum, I suppose. At one end, you've done everything that you possibly could. You've consulted an accountant, a specialist, whoever. You've taken advice. You've done what you thought was right, but something has gone wrong. You've taken reasonable care. You believed that everything was right. At the far end, you knew what you were doing was wrong, and you still did it. HMRC would call that a deliberate error, or effectively fraud. And there are some shades, depending on what area of tax we're looking at, there are some shades in between where you may have carelessness rather than reasonable care. So you've got this spectrum of behaviour on which errors sit. And then within that spectrum, in terms of furlough, the kinds of things that might go wrong, I would have thought the most frequent error is going to be sitting at the potentially reasonable care or maybe careless end of the spectrum, where it might be a pure arithmetical error in terms of looking at, what was the individual earning, how do we calculate what the 80% is, making some error there, or perhaps if you've got a very large payroll within an organisation, somebody's left, it's missed for a month that they happen to have left, but you've still claimed a furlough payment for an employee that's gone on elsewhere. Administrative or arithmetical errors could have happened, and particularly, the guidance was changing, people were getting to grips with it, that kind of thing, it will have happened. And HMRC has made clear that it's not looking to punish hard those kinds of issues. Further along, there are those who really should have done a lot more and didn't do much to understand it and took a very basic view as to what they should be claiming and how, probably sits in careless. And then further on from that, in the deliberate world, you've got things like perhaps employees have left, but you're continuing to claim for employees that have left the organisation. It could be that you have, at the very serious ends, managed to manipulate past returns so that you're overclaiming. It could be that some organisations have been claiming for employees and then not actually paying those payments to the employees. So perhaps they've let, people on 0 hours contract, they've said to those individuals, we don't need you in now for the next 4 months, but then they've claimed the coronavirus payments, and they haven't gone to the individual that they should have gone to.
So we'll deal with the I suppose the intentional misclaiming a bit later on. For now, sticking with those that are obviously mistakes, and probably mistakes that are less on the careless side, they're just inadvertent. What should be done about them? What should a company do in order to correct those, and what are the timeframes in which to do them?
So within 90 days, you should be making a correction if you become aware that something's gone wrong, and should be notifying. There are also some limits as well around when and when you wouldn't necessarily be subject to a penalty. So for a sole trader, for example, if you're a sole trader and you have employees and you've been making claims and you've realised, you know, something's gone a bit wrong and I need to fix that. As long as you're fixing that and notifying HMRC before January next year, and as long as you were not aware at the time that the claim was wrong, so you kind of realised later on, you won't be subject to a penalty if you're correcting before January, the end of January next year. For a company, if you're correcting within a year of the end of the accounting period in question where something's gone wrong, similarly, as long as you didn't know at the time that you'd made an error, as long as you're notifying within that time and putting it right within that year, then you won't be subject to a penalty.
Okay.
You can also kind of make things right in one of two ways. One is if you're about to make a further claim, you can adjust that claim. You can make an adjustment so you can remove the overpayment from the next claim that you're making. Or you can contact HMRC and say, we need to pay, you'll get a payment reference and you can make a payment directly to HMRC to put that right.
And what do the penalties look like, Jeremy?
The penalties depend on behaviours, and in relation to failure to notify in a furlough payment, and what that means is there's legislation that's been put in place which, if you've overclaimed a furlough payment, it effectively turns that into an amount of tax that HMRC could reclaim. So if you fail to notify that you're subject to this tax because you've overclaimed a payment in the past, the penalty could be up to 100%. So if your behaviour is deliberate, if it's fraudulent, the penalty could be up to 100% of the overclaim. So £100,000 overclaimed, £100,000 penalty. If at the other end of the spectrum, you've got a reasonable excuse for not notifying, you didn't know it was wrong, you took advice, you did everything that you possibly could, there was no reason that you had to, that you should have believed that this was wrong, you won't get a penalty. If you don't have a reasonable...
But is that even if you miss the timeframes for disclosure?
But you need to be within the timeframes for disclosure. But if you've got a reasonable excuse for not knowing something was wrong, potentially you're going to be out with the penalty. For a if you don't have a reasonable excuse for a non-deliberate error, it can still be up to 30% of the amount of the overclaim. Penalties with HMRC can always be mitigated. So as long as, you know, if you're forthright with HMRC, help them understand what went wrong, quantify what went wrong, you can reduce the penalty, but it could be up to 30% in those instances.
And someone's asked here, are the penalties additional to the repayment of the furlough sum? And I think the answer to that is yes, isn't it?
The answer to that is yes. And the other thing to bear in mind in relation to companies as well, there exists the ability in relation to the penalty for HMRC to move that from company to the officer of the company who's potentially responsible, if that person has individually benefited from it, or if the company is about to go into some kind of insolvency process. So there isn't a corporate veil, so to speak, automatically in relation to that. HMRC can move that penalty to an individual.
Understood. Okay. And talking about that, I suppose that crossover from corporate to personal, you know, one of the areas that I come across a lot on the restructuring and insolvency side is issues surrounding dividends, salary, how money is taken, especially in circumstances where a company's in financial difficulty. But it did strike me that dividends and salary would be an issue potentially in terms of the furlough claim, because where you had directors who historically had received, I suppose, arguably a market salary, but had taken a tax efficient way by taking a minimal salary and a larger dividend. A, what were the opportunities to change that for furlough? And B, what difficulties may that bring in the future where that's been done?
The way that furlough operated was, there's always a kind of a look back at what people were earning in terms of calculating what is the 80%, or are we up to £2,500. If somebody has managed to game the system, you know, every year they take £7,000 in salary to make sure that they're paying some national insurance or whatever the number is, and £100,000 in dividends. if they've managed to manipulate, and that's always been the case, if they've managed to manipulate the system such that, well, no, actually, I've always taken £25,000 a year, 30,000, whatever the number is, as salary, and they start claiming as an office holder for that amount as having been previously under pay-as-you-earn, HMRC is clearly going to take exception to that. It's not what you were earning previously. Will it have been easy to do? I don't think it necessarily will have been easy to do, but if it has been done, HMRC is going to frown on it.
Okay, and an issue we'll come on to later, the IR35 issue and consultants. But again, it struck me that you may see situations in which companies had retained consultants historically, but who may otherwise look like employees, and may have converted them to employees for the purposes of benefiting from the furlough scheme. Presumably that's likely to bring problems as well if HMRC look at that later down the line.
It could do. You can actually pay contractors operating through PSCs furlough payments if that relationship has already been judged to be within IR35. So if it's already been judged to be within IR35, deductions are already being made on that basis, and the calculations being made on that basis, a furlough payment could be made. But again, like with the director and the dividend example, if you're manipulating the facts or manipulating what you're presenting to HMRC to be something that it is not, again, they're clearly going to be frowning on that. So if you suddenly decide this looks like IR35 just so that you can make a furlough payment, HMRC isn't going to like that. Or, let's employ you because we can then make a furlough payment to you in the future or now. Then again, HMRC potentially is not going to appreciate that.
Yeah, of course. And one last thing before we move on to the more murky side of claims that have been intentionally made. For my information, actually, where you have overpayments that have been received and they are due back to HMRC, how do those payments rank in terms of what are they? Obviously, preferential status has changed in insolvency, and the likes of corporation tax would be an unsecured claim. The likes of income tax, PAYE, would be a preferential claim. So where does the repayment of monies to HMRC sit there?
In terms of the furlough payment itself, the payment, let's say £100,000 gets made to a company and it turns out that £20,000 of that was incorrect. That in and of itself, I don't think has any element of preference. It's counted as tax in terms of how HMRC can reclaim it. I don't think it has any preference. However, when companies or any employer was operating furlough, the payments that were being made to the employees should have gone through payroll just as normal and been subject to pay-as-you-earn and NICs. If that pay-as-you-earn and NICs has not been passed across to HMRC, then I can't see any reason why not, just like the preference that's now on those types of payment for HMRC, I don't see why that wouldn't also be subject to some level of preference as well.
Understood. So thank you for that. Moving on then to the fraud side of the furlough scheme and these estimates around, some fairly large numbers in terms of what may have been intentionally misclaimed from HMRC. What types of things are we looking at with the fraud side?
There's all sorts of ways, and I've tried to put my fraudster's hat on and think about this. If I was going to commit fraud, which of course I wouldn't, how would I do it, and where would the opportunities be? Or what are the things that you could imagine that people might do in those circumstances? There's a range of things. The really serious end, hijacking the identities of companies, hijacking payrolls, and making stuff that's completely fictitious, and you're probably into the realms of organized criminal gangs who are able to do that. You've also got, like I mentioned before, where employees have left, and maybe they weren't UK nationals, and so people, when the whole pandemic started, they decided to return to their home country, and you continue to claim for them as if they're an employee, so they're not doing anything. And obviously not pay them money, or you put people on furlough but you tell those individuals that they've just been laid off, and again, you would, a company or an employer would retain the payment and not make it to the employee. Potentially you could be claiming it, not paying the pay as you earn, etc. And the other thing that companies might have done, and some of this might have started off as inadvertent at the beginning, but the publicity around this was sufficient that I think there's only a very short period of time where you could claim that this was inadvertent, would be claiming for furlough when an employee is actually working, because the rules are very clear that employees should not be working. They could do other things, they could do training, they could go and find other employment, but they shouldn't be working. And so where you've got an organisation that's claiming furlough and using that to supplement wages or pay all of the wages, but still expecting employees to turn up or work from home or whatever. Very early on, maybe you've got an excuse, but the rule was pretty clear. So I think, apart from the very, very first part of the period, HMRC would view anybody doing that as doing that deliberately.
Yeah, I mean, I saw a stat, which I think I've mentioned to you before. I saw a stat that in the first quarter of 21, there was a 743% increase on companies being struck off the register compared to Q1 last year. And there is clearly a lot of debate about the B bills and C bills loans, and to what extent, certainly on the B bills side, there may have been fraud. But there will presumably be an element of risk there with companies closing down where they did run payroll schemes and they've been closed down without a formal process.
Yeah.
And so from HMRC's side, what are they going to do about fraud?
HMRC tackles fraud in a number of ways, always has, and I don't see that furlough fraud will be tackled any differently. And that, there are a range of measures, and not just fraud, errors. HMRC has compliance. A significant effort is put into compliance. In terms of fraud itself, HMRC can choose to deal with that either on a civil basis or on a criminal basis. The majority of fraud cases that HMRC deals with are dealt with on a civil basis, and there are various ways that HMRC deals with those kind of civil fraud. Frequently issue of Code of Practice 9 or the Contractual Disclosure Facility. There will clearly be cases, and we've seen, since that July press release in 2020 about the first arrests on furlough fraud, there have been a number of other press releases about arrests on furlough fraud. And HMRC will clearly tackle some of those individuals who've got things wrong deliberately on a criminal basis. They will be seeking a prosecution. It's resource intensive and it's time consuming for HMRC to do that. So it won't be able to do that with every fraudulent case. It would simply be impossible. It may well be that they target some of the very big cases because they're good for headlines, and if they can recover the money, it's good for the exchequer as well. But I don't think necessarily, and HMRC hasn't always just policed criminally. Based on the size of the issue. Personally, I've been involved in a criminal case for a client where there was only £11,000 of VAT at stake. So sometimes HMRC believes that it has to take that approach for a deterrent effect to show that at all levels, if the evidence is there and the intent's there, they're going to pursue it that way. The majority will be civilly.
Sorry, Jeremy. And briefly, I mean, how does HMRC draw that line between error and fraud? And how do you, when you're acting on these cases, when you're helping clients, how do you deal with the disclosure side?
It can be difficult. There are cases that are clearly one end of the spectrum and the other, and it's at the margins where it's difficult to assess. Where's the margin between carelessness and deliberate behaviour? And in fact, we use so careless or so negligent that there is no other. Fraudulently negligent, if you see what I mean, that you decided not to look at any guidance, get any help, and you behaved so disastrously that it was deliberate. Those cases at the margin, and between careless and reasonable care, those cases can be difficult. But it is an important distinction to make. HMRC more frequently has been asserting deliberate behaviour, and that's certainly what we're seeing in cases that we're dealing with. In the past, HMRC, and quite some time ago, was probably less likely to make any assertion of deliberate behaviour if it was a technical kind of issue. More likely to do so now. But in terms of making a disclosure, the behaviour is always is going to impact the penalties. It's going to impact potentially the period of time that HMRC can go back, or the period of time that you want to disclose for. So understanding, what did a person know at the time? What did they believe at the time? And at that time, when they submitted their return or made their claim, what did they know? And if they knew it was wrong and they still did it at that time, it's clearly deliberate. But if at the time they simply did not, and there's good evidence that they didn't know that it was absolutely wrong, potentially not deliberate, or very likely not deliberate.
And one of the key areas for you, presumably, is how you go about the disclosure, what methodology you use to act in the best interest of the client to protect them from the risk of the criminal side, and making sure that wherever possible these matters are dealt with in the civil realm.
Yeah, I briefly touched upon Code of Practice 9 or Contractual Disclosure Facility before, and that's something that HMRC offers to people in cases where it suspects fraud. And the way that process works is a bargain is made between HMRC and the individual, where HMRC says, you tell us everything, quantify everything, cooperate, and we're not going to prosecute. We'll deal with this civilly, we'll have the tax, the interest, and the penalties, and then the matter's going to be closed. If you're dealing with a case where somebody that you're advising says, I know it was wrong, it was deliberate, I know, I put my hands up, I did it on purpose, I knew it was wrong at the time. Clearly, they may well be at risk of prosecution in those circumstances. But as well as HMRC giving Code of Practice 9, you can also ask for Code of Practice 9. So you can say to HMRC, we've got an issue, we want to disclose it under Code of Practice 9. All other things being equal, and unless there's already a criminal investigation underway, you would usually be accepted into that. And the benefit for an individual who's coming forward to HMRC is they're not going to face the criminal prosecution and that whole process, that they get to disclose on a civil basis and manage it in a slightly easier way.
What I'm very much taken from this is that if there's any uncertainty, come and see you and get some advice on it. In terms of, the questions come in regarding claiming furlough for wives who do minimal work for the company. How would this be treated? And I think this can possibly be wrapped into a question I was going to ask you, which is, what will the knock-on effect of investigation into CJRS be? If there has been some, tax practice in history that have been beneficial, but may not have been strictly within the rules for the purposes of HMRC looking, presumably, if HMRC pulls a thread, noticing things in their examination of the furlough scheme, that's likely to lead to them going into further investigations.
Yeah, if there is a serious investigation by HMRC, usually before launching into it, well, definitely before launching into a criminal investigation, and certainly into a civil investigation of fraud, HMRC does an awful lot of homework into looking at the employer, whether that's an individual or business, in a great deal of detail. And if as part of that review they come across any things that look risky, it is very likely, and it's often part of Code of Practice 9 type investigations or civil fraud investigations, where HMRC will say, well, this was wrong, and we're not quite sure about these three other things. So either we're going to look at them, or you're going to look at them and review them and tell us about them. And if they're wrong, you need to tell us how badly they're wrong. Or if they're okay, you need to demonstrate why they're okay and give evidence as to why they're okay. So turning to that question of paying a spouse a small amount, if they're already on payroll, if they're already being paid to do whatever it was that they were being done, that they do for the business, and the furlough was payments were made on that basis, I don't see necessarily that there's any issue. If a spouse or a child or somebody like that is being paid for doing nothing, then potentially that would fail, just generally in terms of being wholly and exclusively for the purpose of the trade. Would you get the expense? Possibly not.
Yeah, understood. And just finally on the retention scheme, and a question's coming from Walter asking about HMRC and whether they will go for the simpler, more obvious errors as an easy, less resource intensive option. I mean, how do you think they're going to tackle this in terms of what are they going to look at? And are there any specific sectors that you think they're going to be looking at?
Well, firstly, I mean, we'll see if HMRC conducts itself in this way. But if you look at the literature that they've published around penalties, they've said, we want to tackle deliberate fraudulent behaviour. You know, we understand mistakes have been made. If you've made a mistake, as it stands at the moment, it appears that their commitment is they're not going to come down heavy-handed on those that have, you know, it was complicated and they just got things wrong. Where they are going to come down very hard is on those that they can see clearly did things deliberately wrong and deliberately gamed the system. They may well approach this from a number of different ways, from nudge letters that they use in various campaigns anyway, saying, we're not quite sure this is right, do you want to check, all the way through to a knock on the door at 6 o'clock in the morning, you know, asking you to come for an interview under caution. I don't know that they will approach it from just a quick win basis. In terms of the industries, it's difficult to know. I think you can see opportunities for claiming things wrong on purpose in all sorts of industries. I would have thought it's going to be those areas where HMRC can identify it quickest, where you will see the earliest arrests or civil investigations or whatever it might be. So, for example, you know, in a manufacturing industry, if your turnover has remained the same before and during COVID, but all of your employees are suddenly on furlough, potentially quite easy for HMRC to identify that pattern, and, you know, it raises a red flag. How have you continued to make stuff when nobody's working? So it may be that they go there, but equally service industries, you know, if you're still providing services to clients, your employees must still be working, and they will be leaving an audit trail of emails, calls, text messages to clients, all of that kind of stuff. So it remains to be seen, I think, in terms of the industries, which ones are going to be the worst for it, if any are. It may be just across all sorts of industries.
Thank you for that. I mean, clearly it's an area which is going to be talked about for some time to come. And given the numbers and also the fact that the government needs to collect in a lot of money to pay for, or to start paying for the huge amount that's had to be put out there, then collection of tax and the fraud side will be a hot topic, I think, for a while. So moving on then to IR35, which has also been a hot topic for some time now. Can you just give us a brief outline of the background to IR35 and the issues involved?
Sure. So IR35 came into existence in 2000. The objective of IR35, or the perceived problem that it was put in place to try and tackle, was situations where you have individuals who contract with a client via a company, via their personal service company or PSC. But where HMRC perceived that the relationship between the contractor through the PSC and the employer actually looks very much, if you lifted the PSC out of the equation, it looks very much like a relationship between employee and employer. And the problem that HMRC perceived was, as an employee, there would potentially be a lot more tax paid, whereas operating through a personal service company, the end client wouldn't be paying employers' national insurance, and the individual may well be taking most of their remuneration in dividends, which is, you know, in most cases in the past was a lot lower tax rate. So there was this perceived disparity between, you know, the amount of tax paid between an employee and somebody who very much looks like an employee operating through a company. The rules were modified a bit into 2017, whereby public sector organisations had to make an assessment as to whether the contractors that they engage through PSCs are subject or were subject to IR35. So previously, if I ran a PSC, the risk and the responsibility for doing the analysis sat with me to look at my company, look at my relationship with my client, and decide if am I in or out. I was the only person who had to do that. 2017, public sector employers had to do that, or end users had to make that assessment. And then this year, it was supposed to happen last year, but it was delayed. But this year, private sector or large private sector engagers of contractors who operate through PSCs similarly have to make that determination of, is this a relationship that is inside or outside of IR35?
And that idea of the determination, how proactive does a employer need to be versus simply saying, well, I think it's right, so I'll just carry on? Is there an option to ask HMRC what their view is? How will HMRC tend to deal with those types of inquiries?
There is a tool, there's an online tool that HMRC has, the CEST tool, which can be used. There's been a lot of controversy about that tool, and in fact counsel for HMRC in a tax case a little while ago actually argued that that tool couldn't be relied on, although HMRC otherwise does say that it can be relied on. The issue, if you're an engager of a contractor, the issue that you're going to face is in coming up with your determination as to whether they're in or out of IR35. If you decide that they're out of IR35, and HMRC in the future disagrees with that and decides that they're in IR35, if you didn't take reasonable care in coming up with your assessment as to whether they're in or out, you as the engager, the engaging entity, can be stuck with the bill at the end of it. So in the past, the risk always sat with the PSC. If it was found that you're inside of IR35, the PSC is the entity that's going to have to come up with any additional tax that needs to be paid. If you're making careless assessments or spending no time making assessments as to whether your contractors are in IR35, potentially that could land you with the bill now.
And we had a question from Oliver before the webinar started regarding covering off the rules on what a contractor needs to have in place to show that they're not subject to IR35. You and I touched on this briefly in the lead up, and I think that the principle was that it's very difficult to kind of plan out how you're not going to be caught by the rules. It's just a factual basis of whether you are or you aren't. Yeah,
that's a little bit tail wagging the dog. I think the first thing you need to do is understand, between the client and the individual, what is our relationship? What does our relationship need to be? How are we going to work together? And if actually it looks like that is a relationship that is of employer and employee, that's it. If you continue to operate through a PSC, you're going to have to operate IR35, but that's kind of how it looks. In terms of things that you might do, if you're very certain that your relationship is a relationship that's outside of IR35, the way that the courts have looked at this is first looking at the contract between the parties, and then looking at how do the parties actually behave beyond the contract. Is there something else there in terms of how they interact with each other, and then looking at anything else beyond that. So it's certainly, it might be a good idea to make sure that things in relation to how the parties behave are in the contract, so that if it was ever under challenge, it's there in writing. I can substitute somebody to come in for me, or whatever those things might be. But it's a difficult analysis sometimes in a number of cases, and there've been a lot of fairly high-profile court cases recently. But trying to manipulate a relationship into something that's outside of IR35 is probably not the way to be approaching it.
And finally on this, again, going back to that point of disclosure, if you believe you may fall foul of the rules, having had that relationship for some time, what should you do about it?
In relation to IR35, that's quite a difficult question. In fact, if I now know today, or just as an example, if If I'm an IT contractor and 3 years ago I had one client and they just call me in every now and then to fix something in an office or whatever, my relationship with them at that point was clearly not IR35. If now they expect me to be in the office every day, I have my own desk, they tell me what to do, they tell me what to fix, they tell me where to go, etc. My relationship has clearly changed, and it probably looks like a relationship that's in IR35. So if you're trying to make a decision on whether to disclose, it might be quite difficult to determine, when has that relationship changed? If we're starting out with a relationship that looks like the latter one that I just described now, you need to operate on the basis that you're in IR35. Do you need to disclose in relation to the past? It might be quite a tough call to make, particularly as relationships between parties evolve over time. They spend more time working together. You could do, possibly it's something that you'd want to do, but it may be that it's just that your relationship has crept into IR35 rather than always being inside of IR35.
Understood. Graham has asked a fairly detailed question, which I'm conscious we're running relatively short of time, so I'll ask you to pick that up afterwards. And I want to put you on the spot before we finish. Tim has asked how HMRC tend to deal with payment plans, whether they're willing to put them in writing or whether it's right that they will tend not to. They will tend to provide them over the phone and not codify them, as it were. And I just want to join that with another question of mine, which is, there is a lot of tax to be collected. How are HMRC going to go about that over the next 12 to 18 months?
I mean, there's been a bit of a moratorium in terms of enforcement action. So if you're talking about the part of HMRC that just collects money, they don't deal with technical issues, debt management and banking. All they do is collect debts. If there's money owed, they want to collect it. They've had a bit of a kids' glove approach for a while, and I think that they're going to have, given what's happened recently in terms of enforcement activity announcements, they're probably going to have a bit of a kids' gloves, if that's the right term, approach to that for a little while. At some point, that must stop, because you can't not enforce collection of debts forever or get fairly assertive about collection of debts forever. In terms of payment plans, it depends where the plan is with. If it's a payment plan with debt management and banking, sometimes they're not in writing, sometimes they're agreed over the phone, everybody knows what it is, and it's made. I have had payment plans with debt management and banking where they've written to confirm and said, you pay XXX. In relation to,
but there's no kind of policy on it, Jeremy, within HMRC, whether they will put it in writing or not.
I'm not aware of one, and it can be difficult to get a payment plan beyond 12 months with debt management and banking, or with the first line of debt management and banking, the first level before it kind of gets more serious. Usually the parameters are you pay in 12 months or that's it, all bets are off. If it's an inquiry that's being settled in a contract and there's payment that's needed, so you've made a disclosure or whatever it is, and and you're concluding with an inspector, if payment is needed, certainly for direct tax, that's in the contract. The terms are specifically in the contract, and they always are. If you need time to pay, that's agreed. It's in writing. And
so, finally, then. We've obviously talked through the job retention scheme, IR35. Are there other specific areas, other specific trends you expect to see over the next 12 to 24 months from HMRC, areas of investigation that they're going to be looking at?
HMRC runs task forces all the time, so it's always looking at specific industries where it comes across issues that it thinks are perhaps common across lots of entities within a particular industry. One thing that we've seen a lot of recently, and I think it will probably continue for a while, is issues in relation to property. A lot of the cases we're dealing with at the moment, which have serious problems, either started because of property issues or contain property issues, because HMRCs has lots of data. It pulls lots of data together to find risks and identify problems, and it's getting better and better at doing that. And one of the areas it seems to have got better at doing that is in relation to, for example, people having 10 properties and only declaring 3. So pulling that information together. Offshore has been a thing for a while. HMRC continues to push on that. And again, I think as we see them getting better at understanding the data, foreign jurisdictions are sharing data around the world, not just with the UK. HMRC has been sending nudge letters. And with all of these kinds of things, the first time that HMRC gets piles of data from many, many countries in terms of what the banks are reporting, it's going to take them a while to understand what it means. But once they've actually understood what it means, they may be able to identify, well, this means this. We can see that this type of product actually does generate interest. There's a risk here if it hasn't been declared in the UK. So you may see more of those or a continuation of those.
Understood. So, I mean, I think to summarise our discussion, if I may, in my terms, if I have a tax issue, if I'm concerned about a client, I'll come and see you and figure out how to disclose it and how to deal with it. It's clearly quite a challenging area, but also it feels to me as though you need to understand how HMRC are going to react and approach it in a way that will bring out the best outcome for the client, and that takes obviously a wealth of experience, which I know that you have. We are sadly out of time, so I would firstly I'd like to thank you, Jeremy, very much for sharing your thoughts and for speaking to us today. It's been hugely interesting, and for me, I expect to see a lot of issues regarding the furlough scheme and what I do on the restructuring insolvency side. So it's helpful to know those things that perhaps we should be looking out for, but also how to deal with them when they do come up. Thank you to everybody who joined us today. Please do take a look at the K3 Hub website, www.k3hub.co.uk, where you can find the full agenda to our upcoming summer webinar and CPD training program. We do hope that you found the webinar useful, and please do get in touch directly if you'd like to discuss any of the matters that were raised today in more detail. And as I said, there's one question that came up earlier that I will ask Jeremy to deal with, and there's another one that's just come up which I'll also pick up from Adrian. Lastly, and again, Jeremy, thank you very much for taking the time to share your knowledge, expertise and experiences. And to everybody who joined us, have a great weekend. Thank you very much.
Thank you.